So what about the topic at hand today? The redress of a historically unique injustice perpetrated against the Jews of Europe under National Socialist rule. Today, we are not talking about the Nuremberg trials or the criminal prosecution of the murder of the Jews of Europe, but about the peculiar interest of the National Socialist rulers they had in art. Systematic looting was directed at the expropriation of Jews and art treasures possessed by them, which was recorded by Rosvallon in the Jeu des Paumes and later used as the basis for restitution claims and practices. This is why Maria Eichhorn, who worked as an artist in residence at the Kolleg, named her institutional work Rosvallon Institute, which was first presented at the Documenta and which we were privileged to host here at the Käte Hamburger Kolleg Recht als Kultur. We are now extremely happy that this topic, which we were also able to explore in depth in a conference with the Institut Français and the Commission pour l'indemnisation des victimes de spoliation, CIVS, is now being taken up by Matthias Weller. Professor Dr. Matthias Weller is Alfred Krupp von Bohlen und Halbach Professor for Civil Law, Art and Cultural Property Law, and Director of the Institute for German and International Civil Procedural Law at the University of Bonn. From April 2021, he will be fellow, and he is fellow at the Käte Hamburger Center, Law as Culture. That would be normally at the Max Weber Lecture Hall, but we meet now at the screen. And this is even an advantage for those who are far away and can participate without moving to the River Rhine. You have all read his announcement in the abstract, and I do not want to summarize this in a bad way. But I would like to state that as a proven civil law expert with a special competence in art law, he's particularly qualified to pursue the question of why and to what extent the Washington principles are able to enable fair and just restitution, and to what extent they need to be revised in the light of a culture of restitution that meets the difficult requirements of just compensation and at the same time does justice to the emotional significance for victims and their descendants without being guided only by feelings. This balancing act is what is at stake today and in countless proceedings in which a correction of a social history of injustice is sought, which at the same time opens up opportunities for becoming aware of this history of injustice in a kind of, as I would like to call it, reflexive culture of remembrance. I still was too long, but now it's your turn. You finally have the floor, dear Mr. Weller, and once again, welcome to the Käte Hamburger Center for Advanced Study in the Humanities, Law as Culture. You as a fellow and all the others as visitors of our center. Thank you very much.
Thank you very much, Mr. Gebhardt, for the kind introduction and for having me this term in the Center for Advanced Studies, Law as Culture. And it is I'm particularly grateful for the opportunity to present and share some thoughts on our topic, fundamentals of a restitution culture. I am seeing a lot of friends, colleagues from all different backgrounds and places. I very warmly welcome and I very warmly thank all of them that they have taken time and that they made the effort to be part of this session tonight. Thank you very much. It is the thesis of this presentation that certain fundamentals, structural elements are neglected in the process of restitution of Nazi looted art, fundamentals that should be observed in order to generate chances for justice and thus reconciliation. These fundamentals may form, at the end of my stay, if the best comes to the best, a basis of a restitution culture for artworks confiscated during Nazi persecution. Given that I was invited to speak no longer than 20 minutes to give enough room to the discussion afterwards, and given that the topic I chose would need hours, if not days, if not a lifetime, I will have to confine myself to some essentials. I will address a short list of key points for a restitution culture as I see them. Please excuse my brevity, both in respect to the shortness of this short list and to the brevity of my thoughts on each of the very few points on my list. I'm happy to add to these points in the discussion, to which I'm looking forward. And of course, I will further elaborate on the points made and other points you and others may raise during my research stay here at the Käte Hamburger Kolleg. Let me start with maybe the most fundamental point of any restitution culture, which is acknowledgement. On Sunday, the day before yesterday, our president, the president of the Federal Republic of Germany, Frank-Walter Steinmeier, commemorated the liberation of the concentration camp of Buchenwald 76 years ago on the 11th April of 1945. In his speech, Steinmeier reminded us that at least 56,000 human beings were murdered in Buchenwald. At the front door of the concentration camp, there was the inscription, jedem das seine, each to their own, suum cuique, a phrase that Cicero coined, relying on thoughts by Plato on justice, justitia suum cuique distribuit. Steinmeier observed on this perversion of justice to the utmost degree, and I quote, "It is not only the number of the murdered, it is as well the way human beings were deprived of their rights, explored, tortured, and murdered. It is the reverse of all values, the perversion of the law of morality and humanity." End of quote. In 1999, the German Federal Constitutional Court, the Bundesverfassungsgericht, explained that the German legal order post-war intends and is designed in all of its parts to be the absolute opposite of the one under the Nazi regime. It further held that indemnification of National Socialist injustice as well as the interest of persecuted persons and reparation constitute a particular important public interest, a besonders gewichtiges Gemeinwohlziel of the Federal Republic of Germany. And some more decades before, in 1949, first, according to the legislation by the US military occupation government, the restitution of property, and sometime later, compensation schemes started, individual compensations for the loss of lives, health, businesses, property, sales under value, costs of emigration, etc., combined with public welfare schemes for Holocaust survivors and their families in need. Acknowledgement includes that no payment of money whatsoever can bring back one single life that was taken by Germans, by our people, in the Holocaust. Yet the efforts of Germany for Holocaust reparation are internationally acknowledged. These efforts have reached now the equivalent of nearly 80 billion euros, and these efforts are ongoing. For example, the government provided for a fund of 500 million euros to support survivors of the Holocaust and the COVID-19 pandemic. Acknowledgement includes that the current process of the restitution of Nazi confiscated art under the Washington Principles in Germany takes place against the background and in the context of these efforts. In their common statement of 1999, the German federal government, the German states, the Länder, and the municipalities declared, and I quote, "Irrespective of such material compensation, the Federal Republic of Germany declared its readiness at the Washington Conference on Holocaust-era assets of the 3rd of December 1998 to look for and identify further Nazi-confiscated cultural property insofar as the legal and factual possibilities allow, and, if necessary, take the necessary steps in order to find a just and fair solution." This plays a role when it comes to controversial lines between restitution of artworks and compensation of damages from persecution in connection with the loss of artworks. Let me close my first point by acknowledging that the German restitution and compensation schemes had their flaws. All too often, old Nazis were sitting on the benches and individual compensations were capped to rather low maximum sums per capita. And further, restitution under the Washington Principles started very slowly, but after 20 years, in 2018, amounted to the restitution of 16,000 objects. Let me now go on and to an equally fundamental point of a restitution culture, emotions. The strong emotions connected with the restitution of Nazi confiscated art are grounded in a striking obsession of the Nazi regime with art. Artworks taken from Jews represent formative elements of the injustice and persecution that ultimately culminated in genocide. Today, these emotions focus, amongst others, on an imperfect justice, to quote Stuart Eisenstadt, on a deficit in corrective justice, in the sense of Ernest Weinrib, remaining unjust enrichments. And as we know, an estimated 600,000 artworks were misappropriated during World War II, of which an estimated 100,000 had remained in the hands of others than the original owners until 1998. Imperfect justice indeed. And the core of the emotional impetus to set up the Washington Principles on Nazi confiscated art that call for just and fair solutions for these cases. These emotions, out of concrete and identifiable remainders of unjust enrichments, deserve our full respect, and we should share, adopt, and reinforce them. Unjust enrichment must be remedied because it is one of the clearest cases to complete the unfinished business, to use words by James Bindenagel, to meet the requirements of corrective justice conceptually much more obvious than any measurement of compensation in money for material and immaterial losses could be. It is shaming to see early post-war documents that reject well-founded claims for restitution in a cold and arrogant manner. In this respect, I recommend reading Olaf Osman's shocking account of correspondence with the Dresdner Bank in the 1950s. Over the following decades, and increasingly after 1998, while implementing the Washington Principles in Germany, the emotions about imperfect justice in relation to Nazi confiscated art spread, spilled over, were in fact shared and reinforced by many of us, and ultimately started cracking the front of denial and rejection. Sharing the moral impetus that rises from an imperfect justice means that supporters will react with sensitivity to perceptions of injustice in today's restitution practice. In particular, when they go against the claimants, and there are many examples where we really need to get better, but also including points of irritation in regard to the holders of the contested artwork. Claimants, on the other hand, will have strong emotions about critique as they will perceive it as another round of attempts to obstruct and deny justice, and they will feel threatened in their just cause and in their normative empowerment. In turn, supporters of the claimants' just cause may feel misunderstood by the claimants and denied of recognition of their efforts. If I may make a reference here to Axel Honneth's Recht auf Anerkennung, right to recognition, and I just take out of this seminal book one representative, maybe representative sentence on his theory of social ordering. Recognition refers to the act that expresses that the other person shall have value as a human being and is the source of legitimate claims. The recognition of the other is the condition for one's own being recognized. End of quote. On this premise, justice is a communicative and cooperative project that aims at mutual recognition of the participants within a, if I may use the word Gerechtigkeitsverhältnis, a term that I borrowed from Dietmar von der Pforten, something like a justice relation between the two parties involved. But of course, after the Holocaust, in which our people denied recognition to the utmost extent, we can only offer invitations to return to this mutual recognition. Emotions alone will lead us into deadlocks in this process. Emotions need to be transcended in order to render them productive for justice. I refer here to the concept of justice as fairness by John Rawls and his concept of initial intuitions about justice. Intuitions that should be refined up to an reflective equilibrium, as he puts it, under a veil of ignorance for the participants. They do not know on which side they will stand later on when the conflict is really resolved. And these participants in this situation will frame the so-called original situation, and this is the procedure that will bring about justice as fairness. Can it be by accident that this powerful and recognized concept of the production of justice, of a procedural production of justice, justice as fairness, is textually so close to the just and fair solutions the Washington Principles call for? Could it be that we should interpret the moral plea for just and fair solutions as an original situation in the sense of John Rawls? I think there is some merit in it. This would mean that we recognize the distinct dynamics and functional limits of emotions in the production of justice. Speaking of justice, let me now turn to the next and already last of my 3 points, which is justice itself. Allow me to illustrate the challenges for the production of justice in our matters on the basis of the latest recommendation of the German Advisory Commission of the 26th of March 2021 in the case of Kurt and Else Gravi. Kurt Gravi had purchased the painting Füchse, Foxes by Franz Marc in 1928. After 1933, Kurt Gravi and his family were persecuted by the Nazis. Amongst other measures against family members, all of Kurt Gravi's enterprises and shareholdings were liquidated under duress or Aryanized after 1935. After the so-called Kristallnacht pogrom, Gravi was imprisoned in the Sachsenhausen concentration camp for several weeks. At the end of April 1939, he emigrated via Belgium to Santiago de Chile. He was not allowed to take any assets with him. His wife Else followed shortly afterwards. She sold off all of their remaining assets, but had to pay Jewish property tax, emigration tax, and other levies. With the help of friends, however, they managed to ship the painting in question, The Foxes, to New York. Other friends in New York offered the painting for sale to the Museum of Modern Art to raise money for their living in South America. In 1940, Gravi telegraphed from Montevideo a minimum limit for the purchase price. The museum remained below, the sale failed. Later in 1940, the painting was sold to other emigres in New York. In 1961, the painting was resold now to Helmut Horten. In 1962, Helmut Horten donated the painting to the museum in Düsseldorf. In 2015, the heirs raised a claim for restitution under the German implementation of the Washington Principles. What would be fundamentals for producing a just and fair solution in this case? There are at least the following one in the realm of the production of justice: consistency and procedural fairness. Let me turn to the first: consistency. Treat like cases alike. Since Aristotle, this has been one of the most fundamental elements of any justice. In order to live up to this standard, we would need to make up our minds how we want to approach such cases of flight-related sales, Fluchtgut. We could say that causality between persecution, emigration, and then sale to make a living in the new country is enough to justify restitution. We could consider additionally that a line of causality is always necessary, but never and nowhere enough to establish attribution and responsibility. And therefore, we might want to see more than just causality. For example, a particularly close connection between Nazi persecution and the loss of the property in question. For example, a forced sale, a sale under duress, possibly within the confines of Nazi power, as opposed to sales in safe states outside. But we could also interpret the sale in New York as still under duress due to the economic plights of Kurt and Else Gravi. We might want to include in our considerations that the economic losses of emigration and sales undervalue due to Nazi persecution were, at least principally, compensated under the post-war compensation schemes I mentioned at the beginning. Whatever we do, we should do it consistently. Let's see what the German Advisory Commission has done. In 2014, the Commission decided in the case of Alfred Flechtheim on the point in question, and I quote, "If an art dealer and collector persecuted by the Nazis sold a painting on the regular art market or at auction in a safe country abroad, there would have to be very specific reasons to recognize such a sale as a loss of property as the result of Nazi persecution." End of quote. In 2016, the German Advisory Commission confirmed this and decided in the case of Clara Levy in relation to a sale of an artwork in New York after emigration, and I quote again, "If the painting was sold in New York, which is in a safe country outside Germany in 1940 or 1941, there is no doubt that she obtained what was the market price at the time. It is not to be presumed that the Washington Declaration, even if it is interpreted in the widest possible sense, and thus extended to cover also forced sales or other forms of persecution-related confiscation, aims to reverse sales transactions such as this one, which was effectively concluded under civil law by the rightful owners in New York, and the subsequent resales of the painting." End of quote. Nevertheless, the Commission, in its most recent case of Kurt Gravi, recommended restitution the painting. There is a long reasoning, but surprisingly, it does not offer any distinguishing in relation to these two of its previous decisions. It does not even mention them. Obviously, however, the ratio of this last recommendation is in diametrical opposition to the ratio of the two decisions of 2014 and and 2016. We could now interpret this latest recommendation as an improvement. We could say now the Commission got it right at last. However, the recommendation is in a similar opposition to almost 10 decisions from other commissions in Europe, and there is not one recommendation of those that results in unconditional restitution. The Commission did not take notice of these 10 or so contradictory cases from the other commissions in Europe. It did not undertake any effort for distinguishing, for explaining, for justifying, and I'm referring here to the fundamental concept of Rainer Forst's Recht auf Rechtfertigung, right to justification, in which he explores a concept of a constructivist theory of justice under the flag of a claim, a right to justification. Consistency looks different. Inconsistency undermines the legitimacy of both of the conflicting positions. Unfortunately, inconsistency is widely spread within the practice of restitution on a larger number of controversial issues. Flight-related sales, Fluchtgut, is just one example. We should change this. We must increase the quality, the professionality, and thereby the legitimacy of our restitution practice. We must improve our restitution culture. Let me turn to the other of the two elements of the production of justice, and this is procedural fairness. Procedural fairness or due process is recognized as perhaps the most fundamental element of any kind of justice in modern times. Integral part of procedural fairness is the impartiality of the judge and the neutrality of the bench. Contrary to these universally recognized principles, one member of the German Commission during the video hearing in the case of Kurt Gravi typed into the chat to all of the participants of the hearing directly after the lawyer for the claimants had finished his pleadings, and I quote in translation, "A brilliant pleading. Actually, no one should have to discuss anything anymore. The fact that Horten," that is the one who acquired the painting in 1961 on the market and donated the painting to the museum in 1962, the fact that Horten was close to the Nazis himself makes it even more juicy, and this is still a euphemism. End of quote. Apparently, this member of the Commission had already taken her decision without being willing anymore to hear what the other part would have to say, and tried to push the other members of the Commission prematurely and unduly towards her position. This is the opposite of restitution culture. Depriving a party of its fundamental right to be heard destroys the legitimacy of the entire process and its outcome, and it does not play a role which side is affected. Claimants would be outraged if this had happened to their detriment, and for the same reason, they should not accept it just because it is in favor of them. Claimants deserve the restoration of their rights as a matter of our mutual recognition, our respect and justice as a response to the previous deprivation of their rights, including their procedural rights. Let me conclude. I think it is obvious that we need to work on our restitution culture. There is a lot to do. Many of us are contributing. Allow me to draw your attention to the following initiative in which I am currently involved. Since 2019, we are working on a restatement of restitution rules for Nazi confiscated art, financed by the Commissioner for Culture and Media of the Government of the Federal Republic of Germany. According to the methods of a restatement of the law by the American Law Institute, we are comparing cases and we are distilling recurring principles and rules, as well as points of controversy, for example, on flight-related sales, Fluchtgut, but also on requirements for claimants to establish their moral entitlement, requirements to establish ownership on the part of the original owner, requirements for an artwork in the sense of the Washington Principles, requirements for the relation between the loss of the asset and National Socialist persecution, reactions to gaps in the provenance, the role of good faith acquisitions on the part of the current holder, and approaches to the balancing of all of these aspects and interests involved as they have emerged from practice. Of course, we will include procedure, and there would be a lot to say about procedure if we had more time. We have collected around 1,000 cases. The set of principles and rules to be distilled from these cases will help us to better understand the current practice. It is important to note that it will not be the restatement that decides what is just and fair. It does not intend to produce binding rules. The restatement can merely mirror the practice as it stands. If you do not like what you read, don't blame the restatement, blame the underlying practice and give us your arguments on which your critique is built if you do not yet find these arguments in our commentaries. This will help us to put into context critique and counter-critique. Our restatement wants to be a common frame of reference, a toolbox, an academic endeavor, a book which you can read or not. However, I am convinced that this book will help us stabilizing, standardizing, professionalizing, speeding up, and developing our practice. It will enhance restitution culture, and thereby, this is the most important point and our motivation, it will reinforce the claimant's just cause. Thank you very much for your attention. I am looking forward to your questions.
Thank you very much, Matthias Weller, for this very clear, lucid presentation that entailed not only current cases, but also theoretical reflections with regard to what justice means in this context, and also what type of law or normativity as a kind of soft law might spring out of all these reflections and empirical observations. I find it absolutely fascinating, and I'm sure that those specialists in this imaginative room will have a lot to say, and more comments and more questions, and the round is open. Who wants to intervene now? We had a lot of people who wanted to do that. Perhaps Mr. Zeidler might start, please.
Thank you. Thank you very much. Kamil Zeidler, University of Gdańsk, Poland. I really appreciate this lecture, dear Matthias, dear Professor Weller. It was really so interesting for me, and I think for all of us. But and of course, I'm really impressed with this sentence about the restitution culture and developing this restitution culture. But I have one question. I'm really impressed. I try to follow your research since the early beginning, and 1,000 restitution cases it's really a lot of work. But going from the soft law to international multilateral convention, do you think it is possible, not now, but in the future, to have such convention? Because it is usual that soft law after years becoming harder and harder, and finally it has to be it has to be formulated as a international agreement. Do you think it is a future in our topic? I mean, in the restitution of cultural property. I'm looking forward to your opinion. Thank you very much.
Thank you, Kamil, for being with us tonight and for posing this important question. I think it is telling how effective and powerful the Washington Principles developed after certain difficulties in getting in motion. Many of us may not have expected such a development after 1998, and I think we can be glad to have this development, or to observe this element, despite all sorts of deficiencies and needs to go on. That's absolutely undisputable. The question was, would we see chances to go to a multilateral convention of a binding effect in the nature of a treaty, of a convention? I don't really believe in it. It has been attempted during the negotiations about the Washington Principles. It was not successful to reach a multilateral binding convention. And I would not see any possibility to reach this now. Maybe there is not even a pressing need to reach such a binding convention. We should maybe more work on the implementation of what is set in motion on road. And this is the plea, the moral plea for just and fair solutions. And I think we should go on as well as we can to further implement the Washington Principles by something that I would call restitution culture. It relates a little bit to the question, would we need or would we argue for a national legislation in Germany? There are pros and there are cons, of course, but the core issue would be, how would we concretize just and fair solutions in such a legislation? If it's just and fair solution, I do not believe that we need anything more that we have. If it is going to be beyond just and fair solutions, more concrete, it will be extremely difficult to agree in a legislative process on a meaningful body of rules. So I would say the soft law approach in this field is a good one, a promising one, but we need to observe certain structures of justice, certain elements of justice. A few of them I tried to mention tonight. Thank you.
I could imagine that some questions might also be centered around the concept of restitution culture, but this is up to you. Who would like to raise her finger?
By Avraham Root, thank you so much
Yes.
for being here tonight. And by Mayo Moran, thank you so much for being here tonight. Avraham, may we hear your question?
I appreciate very much this lecture, and also professors, personally, Professor Weller, but I would like to make that, first of all, as an Holocaust survivor, I am a little sarcastic that 8 years after, or 76 years after the war, Germany now starts to talk about justice. I think it's a little late. That is number one. Number two, let's not forget that only 1% of the artifacts have been returned. Germany, and not only Germany, also Holland, France, Belgium, they are not the owners of this art. They are the trustees of this art. And as a trustee, you have much more responsibility than you have as an owner. So we should never forget that not the government of Germany should decide what will be happen with all this art, but it should be a question of, in my opinion, of at least as much as of the Jewish community. To my regret, I do not see here any representatives of the Jewish claim of the Jewish restitution, but I know that Professor Weller has contact with them, but this is not enough. And we should have been asked about all this. It's very nice to take out the book, but we have not been asked our opinion about our recommendations about this. The last thing I would like to mention is the paragraph 9 of the Washington Principles. It states very clearly that after some time it will be decided what to do with those arts which are not being returned. I do not believe I heard in the Professor Weller's lecture, and he mentioned about what will happen to all this. And I believe that finally it should come to some trust. It's mainly Jewish trust, but it should never be sold, and it should never be a commercial item. That's what I like to say today. And again, I want to appreciate that they know that Professor Weller does all his best for restitution, but he should also remember the history of the looted art. Thank you.
Thank you very much. Abraham, you raised very important points, and it is an honor to have you here tonight. Let me try to answer to the points as I can recollect them. Speaking about justice is, of course, a challenge in light of the Holocaust, and we must do our best to get in motion towards a constructive dialogue and a constructive discourse. And I think we are making progress, but I fully agree that there are many things left to do, and we must reinforce our efforts. Maybe it's not 76 years after the liberation of the concentration camp of Buchenwald that all of us started speaking about justice. It may have started a little bit earlier, but it can never be enough. Another point you raised is the participation of claimants in our project, the restatement of restitution rules. And you correctly mentioned that we are in contact with the Jewish Claims Conference. I very much appreciate these contacts and the input that we receive from you, from other claimants, from their representatives, and from their organizations, such as in particular the organizations of the Jewish Claims Conference. Allow me to explain a little bit the nature of this project. We are collecting the cases from 5 jurisdictions and try to understand them and to analyze them and to put them into a picture. This is what we are doing in a small university team here in Bonn, and this is a kind of technical work, so to speak. Yeah? It is a lot of work, so to speak, but it is a technical nature of this work. And the outcome will be a description of the reality of the practice. We are not intending to say what should be done. We are in the role of a reporter's team to elaborate on such a restatement and to make available information to the discourse. We are not trying to say at the end of our project what is the right approach. And there will be, so it's no, how can I say, it's not really in this technical work a question of including all interests. Of course, the claimants first and foremost, but first we need to go through this technical phase of the project. And then there will be a draft, as it is always done in the American Law Institute. There will be a draft, and this draft will be sent to you, sent to other claimants, sent to the organizations, and then we really invite all of you to submit critique against the rules that have emerged, because these are not our rules. These are the rules that have emerged from practice. That's the idea of the project. That's important to me to make this clear. Third point, the objects held by the federal government and other governments in a trustee relationship. I fully agree that whenever there is a trustee relationship, there is a particular responsibility, a moral responsibility to achieve just and fair solutions. I fully agree to your last point. Thank you. There is another hand.
Thank you very much, both of you. And who would be the next, please?
This is Mayo Moran. I'm not sure. I have my hand up. Is it okay to ask a question now?
Yes, of course.
Thank you. Thank you very much from the University of Toronto. And thank you, Professor Weller. That was really a terrific talk. And thank you for the Herculean task you're undertaking, trying to pull all of these cases together. It's going to be, I think, an extremely important document. I did want to ask you a question and perhaps press you a little bit in your analysis of some of the cases, particularly with the emphasis that you seem to put on treating like cases alike and the element of consistency, which you rightly attributed, of course, to Aristotle. And it is a very important value in justice, but I did want to ask you whether or not you thought it should receive the weight that, at least it seemed to me, you were according it in a situation where the norms are changing so dramatically. Typically, one would associate that with fairness and treating cases, obviously, that are the same way. But if we have an evolving conception of justice about particular issues, that leads us to believe that some of the ways we've treated matters in the past are no longer the appropriate way to treat them. And this does seem to me to be an area that's characterized by that kind of normative shift. I just wonder about the emphasis on treating like cases alike, and I wonder if it might be a more muted value in this context. Thank you very much.
Thank you, Mayor, for
Thank
being
you.
with us tonight. It's a real pleasure. And thank you for your very important question. Of course, justice is a matter that evolves in time. And so what we see as evolvements, we will describe as evolvements, but the aspiration or the requirement for justice would be to give reasons why cases of an identical setting would be decided now differently than before. And this is what a good court would do all the time. Think about the European Court of Justice. Contrary to what we have decided before, we are now deciding this and that. There are examples, rarely it is the case, but there are examples in the jurisprudence of the Federal Court of Justice. We are giving up our line of case law for this and this reason, and from now on, we are doing it that way. It raises new questions of the rule of law and the trust in the status of the law, but there is evolvement, but it needs to be justified. It needs to be supported by reason. And this is what I'm missing in the last recommendation. And this is not just a formality. I would say it is a core element of the production of justice, because otherwise the new decision is not plausible to the observers. And this is something we should avoid. If I may take up one question in this context from the chat by Imke Gielen. Thank you, Mrs. Gielen, for being here tonight. That's great to have you. And you rightly, of course, rightly asked why I did not mention two more cases that resulted in restitution, but I think you know the answer. In these two cases where Fluchtgut resulted in restitution, it were representatives of the Nazi regime directly who acquired the objects in Switzerland. And that is, as we suggested, one possible reason why these two cases resulted in restitution, and the other two cases that I cited, Clara Levy and Alfred Flechtheim, did not. But in all of the four cases, well, the two cases that ended in restitution and the latest one, there is no reasoning on this reflection. It's just a speculation of many people in the community, and allow me to say that is not enough for producing justice.
I have a question.
Yes, please.
Good evening.
This is Alfred Fass, yes. Go ahead, please.
First of all, thank you for having me here. I would like to rectify my old friend, Mr. Roets. He says that no Jewish organizations are attending, but I'm attending tonight for the Center of the Dutch Jewish History in Israel, where indeed Mr. Roet himself used to be chairman. So I'm happy to announce that I do represent a Jewish institution, and I'm talking from Israel. And in 5 minutes, you'll have to excuse us because we have here the Memory Day for the Fallen Soldiers. In any case, what I wanted to ask you, Matthias, and I think we personally also talked a couple of times about it, is the culture of restitution. As you know, I'm not a lawyer, and I do appreciate that you are a lawyer and that you're looking at the restitution as from your field, your expertise, and you have certain rules, and you want to, I think, what you try to do is to put the restitution in a perspective of law and justice. On the other hand, there are the Jewish families, the claimants, and I think Christine Koenig also can talk about claimants, and we've been trying to get claimants together because I'm personally also a claimant, as you know. And there the justice is important, but a lot of other consideration come into play. And how do you, and I know you're thinking a lot about it, could you tell us a little bit more how you would like to level out these two very important equations, justice and the emotional and very personal grief and belongings of the claimants?
Thank you very much, Alfred, for being here. It's great to see you here, and thank you very much for your important question. I focused tonight a little bit on the issue of justice and the production of justice. I'm not intending to restrict restitution culture to this issue of justice. Nevertheless, I would consider it as at least one core element of any restitution culture. If there is something taken and it is still somewhere else, it must go back. Otherwise, we cannot go forward. I think we agree on that. And that is such a strong element of producing justice that it's worth focusing on it to a certain extent, but it's not enough. I absolutely agree, and I would avail myself of a term that was coined by Rebecca Habermas: embedded history, a restitution proceeding, whether it results in restitution or not, must be embedded in a kind of history, work on history, so to speak, and that would allow to know about the facts, to know the history, to allow remembrance, and to reflect on the history that is connected to the object. That is maybe the overall function of any kind of restitution, but I would remain at my position to say, if there is a case of restitution, there must be first and foremost restitution, and that's the first thing maybe we need to talk about. And that would be my view of the relations of these two. There is a core and there is a surrounding, if I may put it that way, and both of these elements are crucial. Tonight, I was focusing on this core element of producing justice.
Thank you.
If I may say just one sentence in this context, if you allow, I think it is really very important to take the emotive side of restitutional processes from the point of view that objects can be the bearers of emotions. And from this perspective on, it is no longer important if they are great artworks or they are just objects of everyday life. They may even be more important emotionally for a family, for remembering. And that's why I think the project of that Maria Eichhorn has done to focus also on those everyday life objects is also an important element of bringing this negative circus of emotions perhaps into a better direction. I just wanted to underline these this emotive side without saying this should be the last criterion for justice, reflections on justice.
Thank you, Mr. Gebhardt. I see Niv Goldberg and I see Rüdiger Malo. Thank you to both of you for being here tonight. Rüdiger Malo, that's maybe the moment. Thank you for being here.
So good. Thank you very much. Good evening to everybody. Good evening, Mr. Weller. Unfortunately, I came a little late into the talk, and so I don't know exactly if this point was addressed. So my name is Rudi Marlow from the Claims Conference, and when we talk about justice, we also talk not only about content or the way how we, it's not really law because it's soft law, how we do this with the soft law. But we are also, there's also a point that is important to raise if we talk about justice. It is a point about the processes. It means like, this is how can a claimant, or what step the claimant has to do in order to be able to ask back his or her painting. Yeah, and is this also part of it? Because as we much know, most claimants are outside of the countries of Germany or the Netherlands. And once they want to go into the process to getting back their looted paintings, they have to take a lot of steps that are very burdensome. So is that also part of fair and just solution in your view, Mr. Weller?
Thank you, Mr. Mahler, for this extremely important question. And the answer is very definitive from my perspective. Absolutely, yes. I would interpret even the word "and fair" as directly referring to procedural issues of justice. But that's only my personal interpretation. Even if there was not the addition "and fair" in the principles, the word "just" would absolutely include and foremostly include procedural justice. And we must work much more on procedural justice availability of remedies, including predictability, because we are approached in our project again and again by claimants who tell us we approached the museum X and Y and we told them our case, and they somehow started reflecting on the whole issue, apparently for the first time, but then they developed their criteria and we were not informed what are the criteria, and so on and so forth. So standardization of the substantive criteria to establish a claim, or maybe sometimes not establishing a claim, that is essential. Standardization is a core issue to make available justice quicker and with less effort. This is something N. Weber highlighted in our hearing at the European Parliament at the Jury Committee in 2019, where I had the honor to serve as a moderator of this panel, and I fully agreed to her in this respect. So we really need to go forward to improve our remedies, the availability of the remedies, but one part of it is to have a reliable assessment framework to see whether there is a claim or maybe there is not a claim. That would be essential to me, absolutely. And the restatement will cover, to a large extent, these procedural issues, to which belongs, if I may say that, impartiality of the panel. Niv, are you ready now?
Yes, thank you very much. Thank you for also taking the question before me. And thank you for this evening, which is very informative and quite interesting. You largely speak, or at least in the context of this evening, of justice when there is a case. The case is being brought forth to be adjudicated. But there's another step that precedes this, and that is getting to the point where there is a case. And one of the things that I have come across, which I see as quite problematic, and
part of that problem has to do with the applicable law, as I understand it anyway. And that is, at least in the Western countries, Germany, Holland, Austria, France, but in this particular case, I'm speaking about Germany, there was systematic listing of looted property that was done once the Jews were deported or left, one case or the other. You know, the Reich sent assessors, and they made lists of everything that was in the house, and sometimes a week or 2 weeks or a month afterwards, most of these things were sold off, and there are lists of who bought these things, at least on the first hand, or where the first station after the house is for this property. And to take an example, a lot of these are held in the Oberfinanzpräsident Berlin archive. And the problem is that these archives are not very accessible. So, for instance, to get information from the Oberfinanzpräsident Berlin listings, one has to more or less demonstrate that one is an heir, and one has to know that this even exists, and on one's own initiative, write to this archive and ask, is there a file? And at least until recently, I've heard better reports, but until recently, the chance of getting an affirmative answer when there was a file, sometimes yes and sometimes no. There wasn't very consistency. Today, I understand that there is consistency, but there's still a problem of that these lists aren't publicized. And I'm not even talking about the contents of the lists, but even the names of the people whose things were taken. And I've heard that often I've heard that the reason for this is a reliance on privacy laws that don't allow this. And I guess, in addition to just saying, I think that's ridiculous and that needs to be changed and quickly, I wonder if in your project, in addition to surveying the case law and things that result in restitution or non-restitution per case, you are also taking a look at the fundamental legal structures that may prevent people from establishing claims in the first place. Because, I mean, if we're talking about this archive, these lists I'm talking about, I know because I've seen many of them in a former position that I had, that we're talking about the possessions, and not necessarily artworks, I'm not talking about art, but the possessions of tens and maybe hundreds of thousands of families. And the publication of these lists, or they're being made accessible so that people know that, gee, that looks like my grandfather's name. I'm going to write and see if that's available, if there's something there. That could open up this field in a way that nothing has done before. So I guess, what is your take on that? And do you anticipate your research also addressing this side of the legal question of making these kind of lists accessible?
Thank you, Nick. This is another fundamental point you're raising, the effectivity of remedies, the access to remedies, and you have to establish the documentation in order to establish a claim. Let me start in that way. We were commissioned by the Deutsche Zentrum Kulturgutverluste to provide for a legal opinion on the question, how far would data protection law, the new data protection law under the European Data Protection Regulation, allow transfer of data relevant in our field, provenance research, in order to establish claims for restitution. And our result was based, amongst other considerations, on recital number 158, that insinuates a little bit that the member states of the European Union should allow research in order to go into historical injustice, in particular in relation to the Holocaust. Unfortunately, the European legislator did not go as far as to say it himself in the regulation. We called for that in the European Parliament's hearing, that this should be reconsidered. We would like to see a clear-cut justification in the regulation that allows transfer of data, that supports research, historical research on the Holocaust. We want to see that. But we believe, and this is the result of our legal opinion, it's a public one. If anyone is interested, we are very happy to send it over in our legal opinion. We come to the conclusion that even if it's not expressly in the regulation, nor in our German data protection implementation legislation, it is still already the law. Why? Because the German Constitutional Court in 1999, the decision that I mentioned at the beginning of my presentation, stated that redress, reparation of the Holocaust victims is a fundamental objective of this state. And this justifies the transfer of data. That was our opinion. Unfortunately, there is not yet confirmation by a court or by any kind of data protection agency, but we really believe in our work. And I would like to see a reform on this point, be it on the level of the European law, be it on the level of the national laws. The door is open. It has been opened by the European legislator, but no one has, to my knowledge so far, taken the way through this door, which is a shame. And we are confronted with the same incidents. We are asking museums to give us information about their cases. Many of the museums support us in a fantastic way, but there are, you will not be surprised, there are museums that say data protection, we cannot do it, and we are sorry. And we don't believe in this position of law, but so far we have left it as it is because we do have the 1,000 or so cases. And so we need to work on them for the moment to get control over them. And we are maybe making another attempt in another row or in another round of work later on. So that's what I would like to see. I would say you do have a claim for access to these data for the reasons I stated. And it's, of course, difficult to enforce them if someone is not cooperating on the part of the archives. But this is something that we see, not maybe regularly, but too often. But it's a kind of, it's a part of our topic that is not directly in the restatement rules because the cases do not relate to this data protection question. So it's something we work on in parallel, but not directly while comparing the cases to make the answer complete. Thank you.
Who's next in this interesting and always nice crowd?
There is a hand by my colleague, Felix Ullmann, is that right?
Okay.
Yeah, thank you. Good evening, dear colleague. Thank you very much for your wonderful presentation. I have a question on procedure. Of course, I fully subscribe to your point that the procedure is of essence. I'm a little bit less sure where does the procedure come from. Of course, I see that we have some guidance by the Washington principles. We can derive some ideas from natural justice, maybe from comparative constitutional analysis, but from these foundations, in which direction do we go? Because I think that the understanding of a fair procedure is quite different in a US courtroom compared to Germany or Switzerland. And also, do we go maybe in a more direction of civil procedure or administrative procedure? I mean, the last question on access to data, of course, has to be answered quite differently, whether we have a public law understanding of the procedure or we go thinking in the direction of civil law. So my question would be, how do you concretize these rules of procedure, let's say, on the second level? Maybe not the foundations, but on the second level. I apologize for this lawyerish question, but I still think it could be an important point. Thank you.
Thank you very much. That's an important question because procedure is of the essence, obviously, as you state. And our approach is to compare the procedural orders by the 5 commissions, and they are partly quite detailed. So they give us a lot of insight about what is considered to be an adequate procedure. And looking at the 5 jurisdictions tells us that some elements are important in one jurisdiction, other elements are highlighted and taken care of in other jurisdictions. And we try to take these elements and suggest something that appears to us to be, I'm not daring saying an ideal procedure, but something that is approaching a little bit more the optimum than the state of the proceedings, the procedural rules in the 5 jurisdictions. But of course, you are right. We must interpret these procedural facets and aspects in the context of their respective legal order. And there are, as you say, administrative procedures, internal administrative procedures like in Austria. There's a kind of hybrid procedure like in Germany. There are ministries involved at the end of the procedures in Austria and in the Netherlands, which is not the case somewhere else. So we do have a lot of different settings. Yeah, we are trying to calculate them out of the bill, so to speak, which is, of course, a kind of approximation. It's a kind of creative process, but it will be entirely transparent. And wherever you feel as a user of this book, this is nothing I agree to, then you are free and invited to depart from these rules that are suggested as some kind of best practice. That is something that we know very well from arbitration proceedings, where we are very flexible, and that is more or less something that should be observed in our procedures as well. And there are recurring questions. Should there be an appeal? How about the involvement of the parties? Should there be party representatives? And we will try to offer arguments for each of these points, which might be the best placed procedure for our matters, of course, then dependent from the surrounding of the proceedings, be it in Austria, be it in Germany, be it in the Netherlands.
However, I would like to insist, not interrupting your important discussion, I would like to insist that procedural justice, if it would be understood as a kind of empty formal concept and not more than this, as not sufficient. But insofar as we see that procedural rules have a substantive justice-related cultural meaning, so to say, then I think we have to interpret, of course, as you have done just in the last minutes, what we understand by procedural rules that are apt for these cases and in the specific legal cultural context we speak about. So I think there is a lot of problems also with the theorizing of Habermas with procedural justice instead of substantivity. But for example, in Weber's Sociology of Law last paragraph, when he speaks about the formal qualities of justice, it looks like as if it was procedure law. No, it is about the recognition of the other in the procedure and to make substantive claims for having a chance that justice may spring out of the procedure and the process. And this, I think, is important, and we should focus on that.
I think we cannot overestimate procedure, procedural justice, fairness, as it is addressed so many times, due process, and we need to do our best to provide a procedure impeccably to restore rights. Otherwise, we are not reaching the objective of our entire endeavor. And yeah, we are trying to contribute to that as a part of restitution culture as well in the project, of course.
Matthias, may I add something
Please.
here?
Yes,
please do.
Please.
I would like to bring it down a little bit to earth. We discussed many times also the claimants who have no idea how to go forward with a claim. And not only that, their claim is not substantive enough. The painting or whatever they claim for has no real financial worth, and they have nobody to help them. Is that also part of the procedure, or can you make that part of a procedure? Because we have a problem here. Many people who know that they have lost art or they want to claim and they just cannot do it. I know my friend Professor Hammerstein, I also discussed this with him, and I think we have to find a way to get an opportunity for the claimants in order to go forward and help them, if it's help from the government or from restitution commissions. And in the latest developments we discussed about the Constam report, we also see a help desk, etc., etc. I think we should put more emphasis on that point.
Thank you, Alfred. This is indeed one of the points that we discussed in connection with the Constam report and the reforms that are currently taking place in the Netherlands. And it is, yeah, how can I say, one of the most important points for claimants to get help and assistance in their search for redress. And the only thing I can report from Germany right now is that there has been introduced a help desk, I believe at the administrative seat of the commission, but I'm not entirely sure now about this detail, but there has been introduced and set up and established a help desk to which I have already referred claimants from Australia. Someone emailed to me and described a little bit his background, and I was very happy to at least be able to refer these claimants to the help desk. I hope that the follow-up was productive and effective. I'm not informed about that because that's none of my businesses as a scholar, but there is this help desk. I would like to see it very well known, well equipped, and effective for in relation to the interests of the claimants. There may be even more elements of helping claimants in terms of provenance research. That may be something that might have to be organized more effectively, more easily, in a more centralized way. Maybe I'm not so much a fan, maybe I should say anymore, of the principle of subsidiarity we are having in Germany, that all the museums are doing their own proceeding, sometimes according to their own standards. Sometimes something goes up to the commission, but very few cases. I'm no longer sure whether that is the best model. It is a unique model compared to the 5 or the 4 other jurisdictions we are looking at in our project. But maybe there is a point in rethinking about rethinking this structure in Germany. Thank you.
We have, by the way, the same problem in Israel, obviously.
Yeah,
and we don't have any decision making.
Yeah, that's right. That's right.
Further comments and questions, please.
There are two questions in the chat that relate to the number of cases. There is one that reads, how many cases did you collect up to now, and how would you describe their character? Well, the data of the number of cases is around 1,000 now. The quality is, there are different qualities of these cases. We do have a very high quality of cases from other jurisdictions where everything is publicized on the internet. The Netherlands are very good in this point. Austria is fantastic. 300 and something recommendations are simply to be found on the internet. That is best practice, I would say. In the UK, everything is on the internet. All the recommendations, there are not so many, but at least all of them are on the internet. And that is very different here in Germany. We have to embark on bilateral communications with each museum, basically. Some round mails are not very effective, so you really have to approach the museums, the holding institutions, and ask them friendly whether they might be willing to support the project. You can imagine how much time this takes and how effective this is. We would like to see that organized in another way. And this situation, this defragmented situation, results in the constellation that some of the cases are very well documented, others are not so well documented, and then we have to operate with press releases. We know that press releases are press releases and not a documentation of a case, but still they do tell us a little bit on what was important to the parties. We would like to see more than the press releases, and in many cases we are receiving material when we ask. But there are some remaining cases in which this is not the case. So that's how I would describe the quality of the 1,000 cases. 500 or so from Germany, and the other ones from other jurisdictions. Another question by Henning Kamann. When you say the Germans looted 600,000 works, and Abraham Root seems to have alluded to that too, do you only mean works that were lost by persecutees, or also works that were sold by non-persecuted persons in occupied countries? Only the first category can fall under the Washington Principles. I fully agree to this distinction. I'm quoting numbers that were given to us by Stuart Eisenstadt in his book Imperfect Justice, as well as in conference documents. That's the 600,000 and the 100,000. That's the estimations we are working with. We do not really need a precise number. We simply believe, to be motivated, it is a large number. Whether it is this or that size, it's not really important to us in our daily work. We would love to know more about that, but these are estimated numbers. There is the distinction you are making, and there is a lot of work to do. That is, that would be my answer to your question. Thank you very much for that. Is there anything left in the chat? I'm not sure.
Malte Sprenger has a question.
Vella, you have been very concerned about inconsistency of the cases. Since you have now analyzed approximately 1,000 cases, how are you going to include your findings of inconsistency in your further work?
The 1,000 cases are relating to very, very, very different points, and we are splitting up these cases and attributing these cases, the points that were made in these cases, to a set of, to a structure, yeah, requirements for ownership, requirements for the status of an heir, other points, with points where a claim may be barred or may be restricted, good faith, cases relating to good faith. Just to give you an example, that's the way how we are trying to get an idea about the overall picture. So we are splitting up the line of points that constitute the normative substance of the case and try to integrate them into a framework. Yeah, and how are we reacting to changes? I think that's the question you are raising. Once more, we are documenting the changes, we are describing the changes, and if we do not find a justification, a reason for this change, we would consider it a defect of the later decision not to react to the earlier decision of the same jurisdiction. Ideally, a commission would react to what is done in other jurisdictions as well. The German Commission has started doing it in one of its recent cases. It made reference to Austrian case law, but that was on an ad hoc basis and only once so far. We appreciate this comparative perspective of the Commission, but it should be strongly reinforced. It is, of course, difficult. We are confronted with these difficulties in our project. And once the book is on the table, it will be much easier to work on a comparative basis. This will be one more advantage of the project we are pursuing. So to cut short, changes in the moral standards will be described and documented. But if they are not reasoned, the later development has not the weight, the justification it could have if there are reasons for a development or a change. I think that's the same how we work in relation to case law from state courts when we work on a commentary. And that's the way we are trying to approach the issue in our project. Thank you.
So I think we have to come to an end of this discussion. I'm overwhelmed by the density of this communication, the multitude of arguments, and also by the fact that one keynote might attract our attention for the future. And I'm speaking about the concept of a restitution culture. We still would like to know a little bit more about that. Is it about communication, better communicative situations? Is it about more exchange? Does it include remembrance? How is it related to a remembrance culture, etc.? A lot of questions. It is value loaded. It has to do with a very important element, I think, at least, and I started with this point. The break of civilization that the Shoah and everything that was around has brought into the world is responded by a kind of legal civilization. There might be some kind of contradictions, but I think this is an important point to understand also not only moral reflections, but the law as such, as part of a civilizational project. And if we are able to embed this in order to deal with this horrible injustices, I think it would be a wonderful result of this evening if we had found at least some tiny new ideas how to go in this direction. That all of us brought us together this night, and I would like to thank all of you, more than 125 people who attended this conference, and especially to Matthias Weller, who has done the work behind, but also presented his arguments in this wonderful way. and to all the participants with their discussions and their contributions.